Hi, Sam.
Hi Mariana, how are you?
I'm good. I'm good.
So today I wanted to talk to you and ask you some questions about entertainment.
That's great. Entertainment law. Here we come.
Yeah.
So you have a few questions for me, huh?
hmm
Very nice.
So my first
Started.
question is, what is copyright and how do I copyright my creation?
Well, we talked about copyright in the past. It's the intellectual property right that protects the original works of authorship. And as you know, the copyright gets created and protected once it is fixed in a tangible form. So of course, I recommend that you file an application with the Copyright Office, but on the other hand, you get protection automatically the moment that it's fixed in a tangible form.
Okay. So my next question is, what is work for hire and should I have contracts with collaborators?
Definitely, you should have written contracts with collaborators. It makes our job much easier and it leaves no room for doubt. Works for hire is an exception to the rule that indicates that the creator is the owner of the copyright, because this would be the situation where an employee creates an original work of authorship while acting within the scope of its employment or in certain other situations. So it's definitely easier and recommended that you have written contracts.
All right. Can I protect a band name, the name of a movie, or a song title as a trademark?
Yes, definitely you can, but it has to be a serious. It can't be just the name of one movie or the name of one book. For example, let's think about Back to the Future, or let's say Chicken Soup for the Soul. So I should rephrase this answer. No, you couldn't automatically get trademark protection, but you could protect a series of movies, or you could protect a series of books, as long as it works as a source identifier of the goods and the services. The name of the bands you can't protect under trademark. I guess you can consult with me, but sometimes bands protect their name under the class 41 for entertainment services because they're going to be performing under that brand. So remember, trademarks identifies the source of goods and services. So if it functions as a trademark, yes. But if not, then the answer is no.
Okay, that makes sense.
Let's hope so. I think I made it very confusing.
I understand. So my next question is, what is copyright infringement and what is fair use?
An infringement of intellectual property in general is when you don't have authorization to use the intellectual property rights of another. And let's remember that when it comes to copyright, it would be the unauthorized use of copyrighted work. You would need a license, right? In the case of the fair use, that is a doctrine that was developed in the US law, is in those cases where you are allowed to use copyrighted work with no license because it's for specific purposes. Most oftentimes, it doesn't have the goal of commercial gain and it relates to educational, for educational services, for educational purpose.
Okay. My next question is, should I send a cease and desist or file a lawsuit to stop infringement?
I don't know any lawyer that would tell you file a lawsuit to stop infringement right away. You know what? It's like asking a professional boxer, you want to be fighting all the time or you need to choose your battles? I do believe if there is an authorized use of the intellectual property rights that you own, you should start with a cease and desist, but the lawsuit should always be the last resource.
Okay. What are publicity rights or personality rights?
Publicity rights, or what sometimes is referred to as personality rights, are the rights of an individual to control the use of the name, persona, likeness for commercial exploitation. And I guess to give you an example, about 10 years ago, I was interviewed by a TV channel in Los Angeles because Kim Kardashian, you know who Kim Kardashian is, right?
Mhm.
Kim Kardashian had sued Old Navy because she was alleging that Old Navy had hired a lady for the commercial that looked just like her. So she said they were using somebody that looked like her, and she wanted to have control over her image, her name, and the use of her likeness. So I hope that that kind of explains the personality rights.
It does. How do I legally incorporate music from another artist in my music video?
And we were talking about how you need to get a license to use the copyrighted material of another one. Well, in this case, we're talking about music. So you should get a license. And whether you're a restaurant or a social club, or you're an organization that wants to put a video together and wants to use the music of another artist, you should either check out ASCAP or BMI and get a license for those rights.
Okay. What legal issues should I consider when obtaining a license?
Whenever you're doing a legal transaction, an intellectual property transaction, you should do your due diligence. So if you're looking to license the rights of someone else, you want to make sure that you check, are they the rightful owner? Are there any issues, any pending litigations? Have they obtained the registration of the trademark or the copyright? So I suggest you do your due diligence.
All right. What is OTT and what is IPTV?
Oh, and these terms are even confusing for me at times. These are like the fancy terms. So OTT is the over-the-top media, and it's a streaming media service that it's offered directly to the viewers over the internet. The IPTV, it stands for Internet Protocol Television, as you have it here, and it's the delivery of television content over the internet. These concepts have been developed more recently, and as you probably know, there's been a difference in how we consumers watch television from the traditional television formats over cable or satellite. Now there is a lot of a streaming service over the internet: Hulu, Amazon Prime, Netflix.
Yeah. My next question is, what should a music band do when they play live shows?
They should know their rights. They should protect their rights ahead of time. Ideally, they should file for copyright protection for their original works of authorship ahead of time. They're probably going to sign a contract with the venue. So it is very important that they know they protect their rights ahead of time. So then there are no surprises, right? So to plan ahead and to know your rights ahead.
All right, so my last question is, what is music publishing and what is sampling?
Well, sampling will be the situation where you use a piece of music of another artist into another song, if it makes any sense. So that would be sampling. And music publishing, there is lots that we could talk about when it comes to music agreements, but that's why we're here for you. If you have any questions about intellectual property rights and copyrights and trademarks, I'll be happy to answer them for you.
Yeah. So thank you for answering all my questions about entertainment today.
You're very welcome. Until next time, Sam.
Bye.